Check out this SE facing criticism and legal obstacles in crypto cases video for a summary of all that is mentioned in this video, and don't forget to support my channel for more XRP updates and some other cryptocurrencies overall. The Securities and Exchange Commission (SEC) of the United States of America has been subject to an unusually high level of criticism. Chairman Jeffrey Jenner has been left in complete disarray by remarks and even court rulings pertaining to the agency's incompetence, biased attitude, and contempt for its own rules. As the November elections draw near, the Securities and Exchange Commission seems to have chosen its scapegoats in the cryptocurrency and SC scandals, according to the most recent report, which is based on people who were informed about the matter this month. The SEC has reportedly suffered significant losses in cryptocurrency cases and has severed ties with attorneys Michael Welch and Joseph Watkins. The two attorneys filed resignation letters citing debt box and digital licensing as the targets of their involvement in legal proceedings in the litigation that debt box was engaged in the Federal District Court in Salt Lake City. Robert Shelby harshly criticized the group, claiming it was devoid of evidence and had made false statements. Shelby acted against the organization in March by placing penalties on them for misusing their authority. Furthermore, the SEC chairman had to apologize after making a number of mistakes and gravely misusing the last straw that ends the pressure on cryptocurrencies is the authority that Congress granted it in the most recent decision, which mandated that the Securities and Exchange Commission cover some of the costs related to the action. Following the events, the head of the Securities and Exchange Commission, Gerber Girl, who is well known for his tough remarks suggesting a crackdown on cryptocurrency, apologized, but the agency's prejudiced stance has not changed. Girl said that staff members would get training so they would exercise more caution in this situation. Person AA2. The Securities and Exchange Commission has taken a lethal position against cryptocurrencies, according to 5 of the Commission's members. The Securities and Exchange Commission is looking for scapegoats and trying to stop cryptocurrency companies from using the latest rulings as grounds for misusing their position in court when an agency official made earlier remarks about XRP coin. This comes after the SEC approved an exchange-traded fund, or they said that it is clearly evident that the SEC is trying to suffocate cryptocurrency and that this situation needs to be changed. The remarks were considered to be the opinions of the individual and were not meant to bind the agency. A deadline of August 31st, 2021, for the SEC to disclose internal Bitcoin trading policies. The Securities and Exchange Commission was required by a fresh deadline extension to provide its internal policies about cryptocurrency trading. The disclosure's goal was to provide insight into the SEC's workings and consider how those policies would impact the case. The deadline for expert discovery has been extended to October 15, 2021. The purpose of this process was to gather professional perspectives and additional insight into the subject matter from experts in the fields of cryptography and security. The deadline for the release of confidential documents has also been extended to
of the SEC and examine how those actions could potentially affect the case. The deadline for expert discovery is the 15th of October until 2021. The time limit for expert discovery was established to obtain insights from professionals in the fields of cryptography and securities. Through the use of this process, the goal was to provide further insight as well as professional perspectives on the matter. The deadline for the release of confidential documents has been extended to January 24, 2022. The Securities and Exchange Commission (SEC) has until February 17 to file an appeal against Judge Netburn's prior order that Ripple Labs is required to disclose some confidential government documents. The CSE Ripple submitted their initial motions for summary judgment on September 17, 2022. Ripple Labs and the Securities and Exchange Commission have both submitted their initial motions for summary judgment, which is a significant move in the ongoing legal process. The motions provided a comprehensive account of the reasons and positions taken by each of the parties in respect to the matter. The court has approved the Chamber of Digital Commerce's brief on September 21, 2022. The petition to submit an amicus curiae brief that was submitted by the Chamber of Digital Commerce, a United States-based group that promotes blockchain technology, was reviewed by the court and approved. Release of responses from the SEC Ripple on December 2, 2022. The comments that the SEC and Ripple Labs provided in support of their applications for summary judgment to be granted were made available to the general public after the deadline on November 30. Rebuttals to the petition submitted by the opposing party were included in these papers, which provided a deeper knowledge of the legal views held by the parties. On December 22, 2022, the Securities and Exchange Commission attempted to prevent the release of documents related to Heinemann. The Securities and Exchange Commission attempted to prevent the disclosure of the Heinemann documents in the XRP case, as well as any mentions of those documents in the court filings of Ripple Labs. During the Heinemann documents, Ripple and the SEC engaged in a comprehensive information exchange regarding the significance of the papers and the potential impact they could have on the case. On June 12, 2023, the documents about Heinemann were made public and disclosed to the public. After a protracted legal process, the records owned by William Heinemann, who had previously served as the director of the Securities and Exchange Commission, were finally opened and made available to the public. The legal struggle was given a new dimension by the inclusion of these documents, which had the potential to be significant in the XRPC case. On the 13th of July, 2023, the court granted Ripple Labs a favorable ruling. A victory for the cryptocurrency industry over the United States government regulators was achieved when Torres ruled in favor of Ripple, finding that the company did not violate the law by selling XRP on public exchanges. Ripple, on the other hand, was determined to violate securities rules whenever it sold to institutional customers. The motion for an appeal from the SEC was granted by Judge Torres on August 15, 2023, and a notice of appearance was submitted for the investment banker declarant. The SEC has until the 18th of August 2023 to file their appeal with the court at the deadline. In its response to the appeal, Ripple stated on September 1, 2023 that the Securities and Exchange Commission did not possess any valid legal foundation for a successful or relevant decision. The deadline for the Securities and Exchange Commission to submit its response is September 8, 2023. On October 3, 2023, Judge Torres denied the petition for an interlocutory appeal that was submitted by the Securities and Exchange Commission C because it did not meet the requirements for unusual circumstances. The branch of Ripple that is located in Singapore was granted a license to conduct its business within the country on October 4, 2023. XRP's trade volume nearly doubled in the past several days. The charges that were brought against the individual defendants, Garlinghouse and Larson, were dropped by the Securities and Exchange Commission on October 23, 2023, with the permission of Judge Torres. The Securities and Exchange Commission has requested that the timeframes for briefings be changed. The agency's opening brief is due on March 22, 2024. Ripple's opposition brief is due on April 22, 2024. And the SEC's reply brief is due on May 6, 2024. On March 25, 2024, the Securities and Exchange Commission filed a request for judgment, requesting that Ripple pay fines totaling over $2 billion. On the 22nd of April, 2024, Ripple Labs presented its protest expressing its disagreement with the SEC's request for fines amounting to over $2 billion and offered to pay a fee of $10 million instead. On the 23rd and 24th of April,